So let's get back to the discussion now. Joining me in studio, Mark Bichachi and Kakai Kissinger, as we delve into or put context into the presidential petition that NASA filed about midnight of Friday, just before the deadline. And of course, gentlemen, thank you very much for joining us here on Kivumbi 2017. By the end of today, NASA should have filed the respondents, or should have served the respondents, and then the respondents have another 4 days. But for you, since the filing of the petition to now, what is your analysis on how NASA has undertaken itself, as well as those who are expected to be served?
For me, from a communication standpoint, NASA is an interesting kettle of fish because, number one, they came out with different things. There was a hacking claim. There was a server that had the right information. There was, we are asking for Form 34s, and then there was the petition. Then during the petition, as far as guys can see, there's no mention of hacking. There's no mention of certain things they talked about, and they still have 9,000 pages worth of documents that they presented. So all this paints a very interesting picture, whether they were prepared for this or they're preparing now for this, whether it is a strategy that they've been holding back or whether this has also caught them by surprise. And the truth of the matter, this next 12 days as they approach are going to be very critical, because even if you remember the filing, it was left to the last minute, which was an interesting thing, because typically when you're doing something, you want to catch the 7 o'clock news, you want to catch the 9 o'clock news. So leaving it to literally the 11th hour is either a strategy or, again, they're just running to beat time. So I am not yet decided as to whether they really know what they're doing. You know, there's a saying that we used to say when you're young, that you're either really brilliant or really dumb. This is one of those situations, whether it's an act of genius or utter foolishness. And to decide that now would be premature, but the 9,000 pages will determine that.
Karai, do you agree? Do you think it was strategy to file in so late, or we were racing against time?
No, I just like how he's putting it. But one, under the law, there was nothing wrong with the NASA filing the petition the last minute. And the reason being, the law gives them 7 days from the date when the announcements were made. So they were within their time to file the petition the last minute. And I will understand where NASA was coming from in terms of constraints. One of the constraints that NASA will have probably faced is when you're filing a case of such a kind of a magnitude, you need to have your evidence ready. And you need to have your paperwork done. Now, doing paperwork within those days, because I assume that at one point NASA thought they were winning the election, so they didn't prepare in advance. But doing paperwork as a lawyer, doing paperwork for those 7 days is quite limiting compared to the magnitude of evidence you want to collect and to prove that the case is worth being taken to court. Number one. Number two, getting a team of lawyers who will actually be there for you, ready for you, and willing to listen to you is another challenge. Number three, they are relying on IEBC because some of these factors are beyond their control. So they are relying on IEBC to give them evidence that probably will help them to file the case. So they had only up to midnight to file the case, and which they were able to file the case. So we need also to give them credit for the efforts they have made in terms of filing the petition. But we have to understand that we have to put this petition into context and understand that this is not the first petition we are being faced in Kenya. Under the new constitution, this is the second petition, because with the petition in 2013 against the same parties, and now this petition that has been filed. But before that, we had quite a number of petitions, about five petitions actually. Remember in 1992, we had Matiba versus Moi petition. That was a presidential petition. We had James Orengo and 6 others versus Moi petition. The other one was Haron Mwau versus Moi petition. Then eventually we came to Kibaki versus the Moi petition. Now all those petitions were done under the old legal framework, the old constitution. But they never went to court, because they were dealt with at preliminary stages. But what's important to learn out of all these petitions is that all these petitions are leading to legal reforms and constitutional changes. For example, one of the most interesting things was in the Matiba petition. The question arose as to whether Matiba's wife was the one to sign the petition. Now, that has now changed in the law, because that was a dispute at that time. Now, a petitioner himself can sign or his selected agents can sign. So there's no winner or loser on petitions. What it helps us is to help us form a legal framework that is good in terms of election petitions.
Yeah.
So it's good to file a petition. Why is it good to file a petition? It's good to file a petition because there's something which we want to learn from this petition, that something went wrong. And that's purely a matter of evidence which will come to a court of law. Now, as lawyers, we are limited. Once a matter goes to court, we are limited in terms of discussing the merits and demerits of the case. So we'll avoid to go into the merits and demerits of the case as much as we can. But yes, it's good that they filed. Let's see how they come out of it in terms of proving their case beyond what I'll call reasonable doubt.
But talking about lessons learned from previous petitions, the 2013 one was a grilling one as well. The next, the 2 weeks of the court cases and the arguments in court put this country at a point where everyone was just holding their breath waiting for the judgment. What lessons for you, Mark, do you think we can draw from the 2013 presidential election petition with what we are expecting to see next week?
First thing, if you're a lawyer, you need to be as eloquent as Kathy Kilonzo. That's the first thing you learn, that her eloquence really catapulted her national profile. But that aside, the key thing that we learned is, as Wakili has said, the most important thing is that electoral petitions help generate a better democratic space. If you remember, in 2013, we had a green book, a black book, a yellow book, and a blue book. There were 4 books that were considered the register. That the failure of the kits was highlighted in that particular place. The availability and transportation of the forms 34As and Bs became a key issue. Now, definitely, if you look at this election, we've solved many of those problems. Number one, we had one register, registered on the KIMS kit. Everyone was registered by the KIMS kit, either biometrically or alphanumerically based on your ID or your passport. That is an important step forward in our democracy. Second step forward in our democracy, we were able to vote on time. Our queue management skills improved. We improved the entire electoral process. So 2013, that is what I learned. But at the same time, I also learned that whereas the court case was very entertaining, you know, it was intriguing, there were twists and turns, and there were many things that were proven that the IEBC at the time had done wrong. But what is interesting to note, and probably Wakili is better pleased to comment about this, is despite the evidence that seemed to be pro-NASA, NASA didn't carry the day. And that's really the question that we need to ask, in the sense that, number one, why didn't they carry the day that day? And two, is filing 8,000 pages more of a petition, is it going to make it easier for them to win this time around?
I think that's where he comes in. He really
and I think, and I agree with what my colleague is saying. I learned 2 lessons. I do recall that I was following up very well on that petition, and I learned 2 lessons. One, and which I think Kenyans, and this is a problem of Kenyans, we don't seem to learn. We learn lessons, but we don't implement them in terms of policy. One of the biggest lessons that came in the 2013 petition was the time frame. Now, the law talks, the Constitution and the electoral process laws talk about 14 days time frame. Now, the petition in 2013 was caught up with this issue of time frame, which is now even compounded by this election. Now, at that time, they were faced with the implementing, that was the first petition under the new Constitution. And they were faced with the actually understanding whether it's feasible or doable to do the petition and complete it within the 14 days. That's why when NASA came with extra documents, about 800 pages, extra documents, during the pre-trial conference, when they sought to add more documents, the court said, no, we cannot look at these documents. Now, I'll break down to you why the court made that decision at the time. Now, that is the biggest lesson we learned. Now, I don't know whether there has been efforts ever since that time, through Parliament or otherwise, to see whether we can amend or change that law to ensure that the 14 days is not sufficient. I'm sure the institution that dealt with this must have said, oh, look, 14 days is too limiting to deal with this election petition. But I'll come to reasons why all of Africa countries stick on 14 days. So that was the biggest lesson I learned out of it. But we are still in that problem. Now, when you see NASA coming to court to file the papers almost midnight, is they were trying to run away from being caught up by the evidence being expunged from the record. So they were trying to get as much evidence as possible to include in the petition. Now the question is, if I had, and it was public, if I had that the Chief Justice was saying that he's very unlikely to sit on a Saturday.
Yes, when he was being interviewed.
When he was being interviewed, that it's very unlikely to sit on a Saturday. You have to take 14 days minus 2 days. So you are left with how many? 12 days to deal with that petition. How they will be able to deal with that petition is extremely difficult. But then the second biggest lesson I learned, and this with due respect to all the lawyers who appeared for NASA at the time, the lawyers who are appearing for NASA at the moment, I am not one of the lawyers appearing for either of the parties, so I can comment on this. The biggest challenge that lawyers find themselves in, and this is where they always get it wrong, is not to be spot on in terms of what law do you, what remedy are you seeking, what evidence do you have to support the remedy you are seeking. Now, if you look at the petition that is circulating, the NASA petition, look at the reliefs they are seeking. So many. Look at the evidence that they have attached to support their petition. It's voluminous. How on earth are you going to analyze these things as a court within that limited period of time? How on earth are you going to have a pre-trial conference of 1 day and actually analyze all these things and justify that this is what you want? So where we have a problem is that lawyers put too much into the petition. Election petition, and it's jurisprudence which is known, and all those lawyers know this jurisprudence. Election petition is completely sui generis, very unique kind of litigation. It's not a trial. You have very few days to prove your case. So you need to be very, very exact what you want. If I want to invalidate election of a sitting president, I should have 1 or 2 grounds. One, I will say it's fraud, for example. Can I come with evidence supporting the issues of fraud? Stick to that. But you can't be asking so much within such a kind of limited time. But that will be what the court will be looking into.
But then does this mean that because of the limited time we have, even the respondents and those who will sit on that bench don't really have enough time to exhaust what's before them?
No, it's
Does it
impossible.
in any way undermine the kind of rulings that they will make?
No, actually, it doesn't undermine the ruling. What it just makes, it makes it very comfortable position for the sitting president. Because the sitting president's lawyers are not going to struggle. It is the burden of proof is on the petition. The burden of proof is on Raila Amolo Odinga. So the sitting president and his lawyers are just relaxing and waiting. Because, look, you are claiming that all these things you are saying happened. So prove them. You have to prove one word by one, a vote by a vote. So it becomes very, very, very difficult. And so for my issue is, and when you look at countries across Africa, most countries limit the presidential petition to 14 days.
And I would want us to discuss that later.
Yes.
But for you, do you think this particular time frame, Mark, undermines the judgments that will be made, the fact that we don't really have enough time to go through everything? As he says, the burden of proof is on the petitioner to prove beyond reasonable doubt that ABC happened.
You know, one of the key things that for me I look at as a communication strategist is I look at this is going to be televised. I'm sure KTN News is going to have cameras there the entire time.
Obviously.
So now the question is, and here's where the balance comes out. The lawyers have a legal case to prove, but this case is a political case on the other hand. So the question becomes, out of the 9,000 pages of NASA, when their lawyers have 3-4 hours to present in a day, do they present what is juicy to the public but irrelevant to the court, or do they stick relevant to the court and forget to pander to the public? That's going to be the hardest thing for them to balance. In terms of either side, either the legal side or having your case presented before the public, because the public will be watching it, this time frame is very short. But at the same time, and you work in TV, you understand this, the shorter the better. The attention span of the average human being has reduced a lot. You know, thanks to WhatsApp and Twitter. You know, we've got 140 characters or less. So basically, the goodness in terms of the public is that we get into this thing quickly and we get out quickly. Whether that works out for the legal side of things, that is a debate that will be had later. But the reality of the matter is 14 days is good for the Kenyan public, because then I will get all the little bits that I need to pick up to form my own personal decision. But now the danger is that my own personal decision, because you see Kenya is largely Jubilee and NASA. So for example, if the court case comes pro NASA, then Jubilee people will say there was not enough evidence. If it comes pro-Jubilee, then NASA people will say there was too much evidence and you ignored it. So it's going to be an act of wisdom from the judges on the bench to be able to balance the public pressure that they will receive, because they're under immense public pressure, and to balance the jurisprudence and the law that carries this particular day.
This being a political case, do you think it's more difficult for those sitting on the bench?
We have three arms of government, and the executive, and the judiciary, and the legislature. Now, what the nature of election, and that's a very good question you're asking. The nature of an election petition is very unique. That's why jurists all over the world call it sui generis. It's very unique, and it has its own circumstances. Even the issue of burden of proof is different, and we'll come to that. And the standards of proof are completely different. What are some regions talked about, the standards of proof? Now, what an election petition does, presidential election petition does, it swings all arms of government into action simultaneously at the same time. One, the executive is rattled. Someone wants to remove me from my seat. Two, Parliament is seated there and watching briefly. Did the laws we pass in Parliament, why are they being challenged, and where did we go wrong? Three, judiciary is there to provide checks and balances and ensure that it has to be done like that. But remember, judges in this country and judges all over the world take an oath of office. And one of the terms in the oath of office is that you swear allegiance to the Constitution. And you have to abide by Constitution in terms of making a decision. So it can be political, it can be anything. But I'm telling you, a judge sitting there from from tomorrow, he owes his allegiance to the Constitution, and he will do what he's supposed to do.
All right.
So he will not fear because of political, it doesn't matter.
The political pressure. All right, gentlemen, let's take a short break. We'll definitely be back with this conversation as we take a look at what other presidential petitions have been there. More than 90% of the presidential petitions that have ever been filed did not go in the way of the petitioner. So we will be putting that into context as we analyze the kind of presidential petitions we've had even in the region, and what this would mean for us as a country from next week, which is tomorrow, from tomorrow when the hearings begin. This is Kivumbi 2017. Let's take a short break. Don't go too far.